All right, thanks everybody. We'll resume and we will hear from the 42A report authors. As mentioned before lunch, for those that were not there, there'll be a verbal closing, and then the detail to follow in writing within a time frame that we'll discuss once we've heard the verbal reply and whatever might be outstanding, so on and so forth. So over to you, Mr. Cleese and Ms. Overwater.
Thank you. Well, look, as with the opening, perhaps if I lead out and then I'll pass over to Catherine to finish off. So, look, I won't talk for long. I've very much sort of jotted down some sort of key thoughts or key things that have come out from hearing everyone over the last few days. So, firstly, just to make the point that for me, there's actually been remarkably little debate around the policy framework, which has been quite encouraging. Often for hearings of this nature, at least for 50, 60, 70% of the evidence is around the policy framework, which hasn't been the case here. So it sounds to me like the policy framework is largely settled. Now, certainly noting the need to do a bit more refinement around some of the language, which the panel identified in opening, and likewise, I think there's a need for a bit further thought around both the strategic objective that sort of sets the scene and also that rural character objective, where Horticulture New Zealand in particular sort of put forward a different view on that. Look, I think that difference between myself and Horticulture New Zealand is it's partly drafting style, it's partly substance, and that substance turns on the degree to which the rural area is about more than just farming and rural industry, but also incorporates a broader range of community activities. So with the community facility issue, in my view, the framework I put forward isn't that farming and community facilities are equal. That's not the case. So farming very much permitted, whereas new community facilities need to go through a consent process. I've been quite careful that the assessment matters around those facilities include reverse sensitivity and urban growth issues. Likewise, I don't think it's fair that community facilities are linked to a sort of a soil or productive potential nexus, because I don't think that's a valid test for a community facility. Community facilities are all about people, they're not about production. And so it will be setting up a false test or an unrealistic test that they could never meet. Finally, I'd also just note that the 25-metre setback that was referred to by Horticulture New Zealand applies to all buildings, whether it's a house, a preschool, or a tractor shed. So that 25-metre setback is there regardless. Of course, community facilities also have to get a restricted discretionary consent where their scale and nature of reverse sensitivity can be looked at. Moving from the policy framework, which as I say was actually heard very little evidence on, there was then a cluster of topics, I guess, that come within the sort of farming activities and whether farming in its broader sense is provided for. The first and perhaps the biggest one of those was intensive farming as a subset. And having heard evidence, I'd certainly accept that definition for intensive farming, I think, could benefit from a bit more thought and a bit more refining. In terms of the outcomes we're trying to achieve, I'm totally on board with the submitters that outdoor sort of runs, where in particular sort of chickens are able to sort of graze, is no difference in principle to sheep or cows in a paddock. And so where that grass cover is maintained, they're not intensive, they shouldn't be subject to setbacks and indeed should be permitted. So I thought I'd done that in the definition. Clearly, evidence has maybe pause and reflect that needs a bit more refining. So that's one aspect of the intensive farming thing, in terms of the outdoor runs. Absolutely, I think we're actually agreed in terms of the outcome. It's just a matter of sort of the mechanics of how we get there. Probably more importantly is about where the housing livestock occurs in barns, and whether that's kind of free-range chickens that can be outside but also spend a fair bit of time in barns. We heard from the goat industry person around that particular sort of type of farming as well. Look, for me, intensive farming, where it is within buildings, within barns, does or can generate effects. And As a firm, we've been involved for council's processing. I've had a number of colleagues that have acted as commissioners hearing intensive farming applications, and they are, in my experience, invariably contentious, invariably require detailed proposal-specific expert evidence around odour, around noise, that take into account topography, local climatic conditions, and invariably are granted subject to a comprehensive suite of conditions to manage effects. And again, we heard from a lot of those submitters from intensive farming industries that the activity is fine as long as it's well managed. And other submitters are at pains to sort of point out how good their operations were at managing effects, which take on board. For me, the only guarantee, though, that they're going to be well managed is if they are operating under consent and subject to conditions that can be enforced. And I simply haven't heard sufficient technical evidence for me to be comfortable recommending a permitted activity pathway where an intensive farming operation without conditions will be able to operate without undue effects on neighbours in the vast majority of cases. I simply haven't seen that level of evidence. So where I'm at the moment is sticking with my original recommendations around intensive farming where it's within buildings that it needs to go through a consent process. As I say, that definition needs a bit more work, but in terms of the outcome, I'm not convinced that there is a permitted pathway that would be appropriate. In terms of other farming related, some more sort of detailed matters, there was sort of pack houses and whether they should be permitted, or whether it matters where the produce is coming from, whether it's just on site or whether they can kind of be drawing in produce from a wider area. I need to do a little bit more thinking about that. Seasonal worker accommodation. Look, for me, I'm pretty comfortable where I got to in my recommendations. I note that Horticulture New Zealand is pretty much the only party that isn't happy with where it's got to. Turners and growers were comfortable with the amendments to the minor dwelling rule that address their concerns. So it is just that one submitter sort of raising residual issues. So I'll give that a bit more thought, but my initial response is that I'm pretty comfortable with where I've got to, and that I think the plan does provide for worker accommodation. It just doesn't label it worker accommodation. Likewise, Horticulture New Zealand raised some concern and sort of provided quite a lot of supplementary evidence around crop protection structures and whether they should be subject to setbacks. I need to do a bit more thinking around that, just in terms of whether they do actually meet the definition of a building. And they made the point that if it has a roof, it's a building. If it doesn't have a roof, it's not a building. But from an effects, it's the sidewalls that really have the impact rather than whether there's a cover over the top. So I'd like to do a little bit more reflecting on that. In terms of earthworks, could definitely confirm the point raised by Lockyer this morning, and I think Fletcher had that rule up on the screen, that P1 and P2 are meant to work independently, so they're as well. So you get your bundle of ancillary farming, earthworks, farm quarry allowance, that's all permitted. And then in addition, you get another 1,000 cubes through P2. So it is very much in addition, not instead of.
Do you think that's clear in the drafting at the moment? Because I'm not 100% sure that it is. I mean, yeah. Dr. Borrett sort of said that's what she interpreted it to mean, but I'm not 100% clear.
I don't think it was clear in the version as notified. In rebuttal, I put in a new clause right at the start of P2 to try and make that very explicit, and I wasn't sure whether she actually appreciated that from the rebuttal.
I'm not sure either, but I'm just looking at it myself. I'm not sure that it's 100% clear that what you've said is clear. Whether the drafting of what you've got there is as clear as that, I'm not 100% sure. So maybe have a look at that.
Yeah, certain to the outcome, I think we're all in agreement what we're trying to achieve. So
Understood.
Lastly, on earthworks, yes, I need to do a bit more thinking about how it interplays with the NES on fresh water, which must admit only came out. I'd largely written that section on 42A report, and then the NES came out. So I think as an industry, we're all still trying to get our heads around exactly what the NES means and what the implications are for that. So I'll do a little bit of reflecting on that as well. That said, that's about it. In terms of that bundle of rules that control earthworks, noise, glare, signage, site coverage, building height, all that sort of that bundle of effects-based rules that are in the plan, actually there's very little dispute, I think, which I find quite encouraging. I think that between sort of submitters, council, we're sort of able to get to a point where actually, broadly speaking, most people are pretty comfortable with it on the whole. The next sort of topic was around Hinds, Synlait, Huntly and First Gas setbacks, and Mr. Chair, I sort of appreciate you've got that sort of Huntly conflict issue. I'll just talk in broad terms, so I don't think you need to sort of...
No, you talk about any of them specifically, and I'll just close my ears to the Huntly stuff. I don't think there's any issue around that.
No, good. Look, as I said in my 42A report, in principle, I have no issue with regionally significant industry being protected because there is, it's a significant sunk cost, brings significant benefits to the community. And I also think the setbacks are a really useful tool to deliver that. But setbacks do also impose significant constraints on third-party neighbours, so they need to be carefully justified. And it's really around that justification where I think I have that sort of difference with submitters and a degree of evidential base to those setbacks. So with the Synlait Hinds, I appreciate my recommendation is a bit of a kick for touch, and it's not that I'm not afraid to have the conversation now, but I honestly think you do need to resolve the zoning first. Obviously for Synlait, if the Hinds greenfield land that kind of wraps around the Synlait plant, if that gets rezoned to heavy industrial down the track, then that largely sort of sorts the issue for Synlait in terms of that 300 metre setback they were seeking kind of gets taken up by a new heavy industrial zone. It then begs the question whether you then need another setback that goes sort of from that new zone boundary again or not. And likewise with the submitters that are seeking residential nearby, it's seeing whether they can put a proposal, I guess, to the panel that appropriately manages that edge effect as well through, for instance, sort of having really large lots around the edge with building setbacks or building platforms identified clear of setback, or I know on other sites you often get stormwater basins sort of put along that interface, which I appreciate here with the topography that might not be a solution, but I think you need to have a look and see what the residential rezoning people are coming up with and whether they can be a little bit more creative than just a sort of an assertion that Hinds and Synlait should manage effects within their property boundaries. So once I think you know where those zones land, then you're in a much better position to know whether further setbacks are required, and if so, what the evidential base for them is. And again, I found it a little frustrating with Synlait that their 300 metre number isn't, on what I could see, grounded in any evidential base around noise or odour or quite where it comes from. At least with Hinds, I got the link to topography, and they were sort of saying, look, we're in this sort of set in this basin area, so it's sort of putting a line around the top of the ridge, which I can understand.
Just before you move on from that one, we got a fairly extensive presentation yesterday from Sir William on the Hodgson scenario, which is on point. And leaving aside zoning, do you have any, and he basically said there's an imposition now being imposed, which is sort of independent of what the zoning of their property is in effect. I mean, it's more magnified if it becomes residential. But in terms of the contest, if you like, between the Hinds evidence and what Sir William had to say, what guidance can you give us on that?
Yeah, I think it turns a little bit on how much weight you give to the operative plan origins that have an aggregate extraction area that sort of wraps around that greenfield area around the Hinds site, and then the aggregate extraction area in turn in the operative plan has a 500 metre setback. So that setback kind of had a benefit to Hinds, but wasn't really there because of Hinds. It was there because of a future quarry area. And then because the quarry, that land is now no longer to be used for quarrying, that overlay's gone in the proposed plan, and therefore the setback's gone as well. So on that setback covered more of the Hopkins block than the setback that Hinds are now seeking. So in that sense, it's Hinds relief is a reduction from where we are in the operative plan. And I guess you could argue the Hopkins have been aware of having a setback requirement there for the last 15 odd years. That's now going to get smaller. So So there is a sort of slight specific history. I guess more broadly, there's a how do you balance heavy industry in general, and whether it ought to have whether there is a
Yeah, I guess I'm aware of that. All of that. I guess I'm asking for your opinion as to which of those two we should prefer on the basis that the zoning. We haven't heard the rezoning evidence, but there's two scenarios, aren't there? One is that the zoning stays as it is, or as proposed, and the second one is that it becomes residential at some point in the future, let's say.
Look,
and let's leave the second one for now, but on the basis of what we've got in front of us, what would you be advising us to do?
Look, I would lean towards prioritising Synlait and Hinds, I think, just given the extent of sunk capital and the sort of the role of those, or the scale of those industries. Plus, I think stepping back at a Pokeno-wide level, I guess when you get to rezoning hearings, you'll be saying, I'm sure there'll be evidence around NPS urban development capacity, how much additional housing you need to be providing. There'll be competing candidates for where that zoning should go, and you'll be having, to a certain extent, to prioritise where that new greenfield growth most appropriately lands. And I think assuming there are other candidates in Pokeno that don't have these constraints, then that to me would suggest that's a good way of prioritising perhaps where that goes. So,
okay. All right, no, that's helpful. Thank you.
Exit industrial area.
I think too, just if the panel have any questions as we go along, let's not necessarily wait till the end. Let's make this more conversational than more interactive to the as everyone wishes.
Just on the Hinds Synlait situation, if we leave the zoning in place now, what did the proposed plan as notified provide for by way of a buffer? Can you remind me?
It didn't.
Nothing.
It didn't.
No. So the operative plan has a heavy industrial zone that's then sort of wrapped by an aggregate extraction zone, and then that aggregate extraction zone has another 500 metre setback. Because the aggregate extraction zone went, that 500 buffer also vanished. So it's just a straight industrial heavy straight into rural, no setback, no nothing.
Right. Okay. And Hinds want to have it on the ridge top of the land they own, plus it extends over some of the Hopkins land as well.
Yeah. Yeah. In a nutshell,
and others, I think too. It's not just Hopkins land, I don't think.
No, it is broader than that.
And Hinds, looking into the future, they want to change the zoning of that to industrial.
Yes, or at least my understanding is it's sort of a kind of in a basin. So there's a degree of sort of flat greenfield land that they want to go to industrial, and there's sort of steeper hill slopes that wouldn't necessarily be rezoned, but would still be within this new setback area, and that new setback area takes in both Hinds on the hill land and other parties, including the Hopkins.
Okay.
Has Hinds sought rezoning of that in their submissions? We obviously haven't got to that point yet, and I know we talked about it in industrial, but I can't remember the answer. Does anyone know?
Carolyn, my understanding is that they do, but I'm happy to stand.
Yeah, I suspect that's right.
Yeah, from memory, they sought rural. They had a bit of a bob each way. They sought rural or I think industrial. Meanwhile, we've got Havelock Villages, which are seeking residential.
Yeah, okay, understood. Thank you.
Just on that point, Hinds have already bought land, haven't they, on Bluff Road?
Yes.
So that, I mean, they've bought that for their own benefit to get the protection. That's what they've done, haven't they? So we're only talking about the land that they don't own and that they've got the or want to put the covenants on. Is that right?
Yeah.
Okay. I think the point that Mr. William was making yesterday about subdivision and so on up Bluff Road, that's what he was talking about. Maybe a bit of a long shot. I think probably country living may develop, but I couldn't imagine residential areas on those sort of hills up there. That's my view at the moment.
I think Mr. Cleese, it'd be good if you, when you give your written reply, just set out, perhaps with attached maps to it, just showing us the difference, and so we can get an idea geographically what we're talking about here.
Yep, no, very happy to do that.
Okay.
No, I had a similar sort of format that I sort of do a series of sort of walk you through, operative plan, as notified plan, as thought by Hines plan.
Yeah.
Yep.
Yeah, that'd be
Just
helpful.
from memory, Mr. Cleese, 10 and 62 Bluff Road is what they purchased. And that, I think that equated to near on 60 hectares in total.
Yep.
And that map would be really good to show the other 9 that Mr. Birch was talking about that are in association with the Hodgson family, where they all lie.
Yep, no, more than happy to do that.
Thank
Yes.
you.
It's quite easy to show what Hines owns and what's third party land. So
Do it.
happy to do that. Cool. So then we heard from Bathurst this morning. Again, we're largely in agreement, I think, that what's called the coal mining area, which is sort of an overlay that sort of sits over actively mined and actively consented areas, should be extended to cover the extent of their licenses and permits. So that was sort of the red areas that they showed this morning that was on that attachment Fletcher put up. So we are in agreement on that point, that there should be provision for those active license areas. That does make it, so it's just from being fully discretionary to restricted discretionary, and also puts a setback for sensitive activities around the edge of that. Where we have a difference in view is around the mapping of just the Waikato coalfields, the sort of the coal deposits, which were the big yellow areas that we showed this morning, which cover thousands of hectares, and then have another 500 metre setback for sensitive activities from the outside edge of those areas. So it is covering sort of literally thousands of hectares. I've been reflecting on this, and I wonder if there is somewhere of a halfway house where potentially, rather than mapping those coalfields on the planning maps, they simply go in as a map, as an appendix to the policy, to illustrate where the coalfields are, which helps to illustrate where coal mining might occur in the future, because obviously coal mining doesn't occur where there is no coal deposit. So it's more as a mapping, as an identification tool to assist the policy, rather than on the planning maps. And likewise, I'll do a bit more research, but I'm broadly comfortable with coal mining in those coalfield areas being restricted discretionary rather than fully discretionary. So I'm comfortable with the enabling aspect of that. What I'm not comfortable with at all is a requirement for no sensitive activities, no dwellings, within any of that coalfield area or within that half kilometre just beyond them, because I just think that takes in thousands of hectares of land on the off chance that a coal mine might land there at some point in the future.
I think we had a good example with the Heniwai redevelopment there. So
yeah, exactly. Where that coalfield extends underneath.
Yeah.
Anyway, so and then lastly on Bathurst, yes, exploration and prospecting. Mr. Leakey in his submissions put forward at the end a sort of proposed rule that he thought would do the job. I've had a quick look at that, and yes, my initial reaction is it looks okay. I'll do a bit more reflecting on that, but I think we can probably get to an agreed rule for prospecting, and as you said, that it tends to be pretty small scale, and the rule that he's seeking to permit is for that fairly modest. It's a drilling rig that you fill up the hole afterwards, or it's all for a day. So that's Bathurst. You heard there were a couple of site-specific submitters, Dilworth and Merrymerry Speedway, or Dragway rather. For me, there are a range of tools to how you address these submitters. With Merrymerry, I do wonder whether, upon reflection, actually rezoning it might be the better approach. So I know Hampton Downs there's a motorsport zone, and whether that zone might also be a better fit for Merrymerry, with maybe some tweaks to the rules around that for Merrymerry. Just at Merrymerry Dragway, really doesn't fit very well at all with the balance of the rural policies. Whereas the other area-specific things like the ag research centres, like the Huntly coal and Ashwater area, which is sort of largely sort of paddocks when you look at it, like Dilworth, which is a country school, I always sort of sit comfortably enough within a rural framework, whereas a dragway facility doesn't really. So that's just, as I heard this submission and reflected on it some more, I do wonder whether it might better be addressed as a rezoning. That said, if it does stay in the rural zone, has got its own policy. The schedule that was in the operative plan really doesn't actually say much more than the one-line rule that's in the proposed plan. It's a one-line schedule. So in that sense, whether it's scheduled like the operative plan, whether it's a forbidden activity rule, the actual outcome, the regulatory outcome is more or less the same. Likewise with Dilworth, that's obviously at a much smaller scale of facility. I'm comfortable with the one-line permitted activity rule approach that we've gone. I'm not sure that Dilworth warrants a whole separate section to my mind. Then lastly, Hamilton UAA, obviously have a difference of view between myself and Hamilton City Council's planner. I think it's pretty clear that we just have that difference of view. The only point I'd make is just to note that sort of spiritual health and community facilities in the operative plan are actually permitted, and that I may not have communicated that very clearly in my 42 report. So the shift is from operative plan permitted to does it go to discretionary, which is what I'm recommending, or prohibited, which is what Hamilton City Council is seeking. So it's not that it's prohibited now and we want it back. It's more going from permitted to something in between. And for me, we heard from the pastor of a church, I think it was, that was meeting in a converted house within the UEA. And that for me was a really good example of the sort of pretty benign, pretty sort of low-key activity that, in my view, doesn't prejudice urban growth at all, and ought to have a consenting pathway to progress rather than simply being prohibited. So that was it, really. Look, in conclusion,
Just before you move off that topic, Mr. Cleese, just a couple of questions around that.
Yep.
Is using the Merry Merry Dragway as the specific example that you were talking about, does their submission have the scope for us to impose a site-specific zoning on it, if that's what we were minded to do?
look, I think it does when you look at the outcome they're trying to achieve, which is really, we want a policy and some rules that specifically provide for dragway activity. And then it's really just a question of what tool best does that.
Okay. No, I think that's probably right. They do talk about they want a dragway park specific area shown on the planning maps, and they want the schedule that was in the operative plan reinstated. So I guess that's probably not a big stretch to say that's a zoning and drag, isn't it?
So to speak, yes. Yeah, no, I agree. I think you say, look, we're not running with scheduling. We agree some sort of site specific. Here's a speedway zone we've got in the proposed plan. Let's apply it here as well with a couple of tweaks if need be.
And secondly, and just following on from that, in terms of these sort of what you might call spot zonings for things that are out of zone,
yeah,
where else does the plan make provision for that? Is this a one-off, or is this something that's done reasonably often in this plan?
In this plan, in the notified plan, I'm not intimately familiar with the residential and commercial zones. Carolyn might have a better handle on that. My impression, well, it certainly doesn't use scheduling. So it's more, are there site-specific rules in those other chapters? Carolyn, do you?
The ones that spring to mind are the Hampton Downs Motorsport Zone is one of them. The other one would be the Te Kowhai Airport.
Yeah. Okay.
So
Thank you.
Yeah, the specific zones rather than schedules or just rules that sit within activity-specific rules that sit within a
Can I ask you a follow-up question, unrelated to the dragway, but in relation to the Dilworth submission? How? I mean, I can see that the dragway is special. I mean, it's the only dragway in the district, like the motorsport park and so forth. How different from, a country school or is the the Dilworth situation? It's not clear to me that it's sort of special.
Well, it's not. I know it is a country school. It looks and feels that sort of scale. Probably the only difference is that it doesn't have the benefit of a designation, or it's not a requiring authority school because it's private. But in terms of look and feel and building outcomes and number of kids and all that sort of stuff, it's no different from a country school.
If we let's say that we said, it doesn't have the benefit of a designation, which is true. It's in the rural zone and it needs to be provided for in some way. Would that create precedent for anybody else that wanted to establish a non-designated education facility in the rural zone?
Well, no, I don't think so. I think it's simply an acknowledgement of an existing situation, and then you've got the was it RD or D pathway for new schools or new education facilities.
I guess so why do they need some sort of permitted activity rule to enable, some sort of expansion of what they're doing? I mean, their argument was even if we wanted to put a new toilet block in, we'd need a resource consent.
Yeah.
Well,
Just hang on that
why
point.
would you need a resource consent to put in a toilet block? But put the question the other way around.
Yeah, well, that's true. That's, I guess, where I was heading for.
Yeah.
There are other facilities in the Waikato district that schools have, and I think Huntley College has one at Raglan, don't they, or Kariori or somewhere out there. I think we'd be careful, if we gave to them one, other schools that have some facilities could ask for the same thing, I think. I'd be a bit careful about that.
Yeah.
Hmm.
I guess probably two quick points. One is obviously some Ministry of Education schools are designated, so they can go down an outline plan route rather than a resource consent route.
Oh, okay.
So they don't have that. It's a different process, really. I guess for Dilworth, my feeling was that there aren't that many other private schools or these sorts of facilities. There is, there's Dilworth, there was the Tamaheri Health Facility, there was the couple of retirement villages who sort of, put some missions in. And I felt that just to ignore them and just so I say that look, you're reliant on existing use rights and nothing better than that was a bit unfair. So I wanted to provide for them in some way, but likewise didn't want to go overboard on that provision because they are pretty discrete facilities. So that's where I ended up on the single rule pathway for them.
Okay, thank you.
Yep. And then, look, lastly, in conclusion, as I was sort of staring at the roof last night, reflecting on the last couple of days, thought actually my overall impression was actually I think we've done really well to have a hearing or a chapter that's as broad as the rural zone with as many different parties and activities and interests. To have a hearing that's been done within 3 days, that on the whole, the objectives and policies people seem pretty comfortable with, that there are large chunks of the planning framework that likewise haven't really attracted much evidence at all. I found quite encouraging. So there also are still some discrete topics of difference, and just sort of summarise those that do require some further thought. But actually, on the whole, I thought with submitters and the work the council have done, actually, I think we're actually in quite a good place. I was being quite encouraged at how the hearing's gone. It was sort of an overall reaction at the end of that.
Sorry, I thought you finished. Carry on.
No, I was just going to hand over to Catherine. So
I was just going to ask you, I mean, and you deliberately said that was quite high level, but is there anything that you've heard other than the matters that you've raised where you've changed your view and said, well, actually, I think there's some merit in what person X has said, and I'll give it a bit more thought, or have we covered all of those?
I think we've covered all of those. There's the odd word here and there that got noted. Understood. Yeah, that's also polishing rather than sort of direction shifts. So no, there aren't any other big changes of direction that I haven't told you about. Okay,
that's helpful. Thank you. Let's just see if there's any other questions before we move over to Ms. Obort, and then we might have a roundup at the end because there's a bit of cross-fertilisation, obviously. Has the panel got any more questions?
Not from me, thank you.
Just, and we'll do it at the end, whether you need more time to look at the mainland poultry invitation to you to sit down with them and work through some, to see if an agreement can be reached. But we'll come to that at the end. But just in the UEA area, I just wonder, and the intention there is to make it non-compliant rather than prohibited. If we were to accept that that recommendation, we've heard from CDL, who said, well, look, you know, we're here to progress that as an urban, for urban development, which it seems to be set aside for, and we're in a bit of a catch-22 here. Is there, if we were to accept the non-compliant status, is there enough wriggle room for a developer like CDL to come up with some urban development plan? Is that recognised in the policy that applies to the UEA?
Not so much coming up with a plan. I think it's more that they, in that situation where they want to sort of, you know, carve off a small lot around the existing house so they can kind of get the big balance lot into their ownership.
Yeah.
I would have thought it's more putting forward the proposition that shift was to facilitate urban growth, and the new lot around the existing house is so small that it doesn't prejudice urban growth, so that therefore it doesn't threaten the policy, would be the route that they would go through. Look, for me, there's probably a bigger question of whether there is a route to sort of shift, you know, that scenario to more of a discretionary rather than non-compliant pathway. But the challenge, I think it may have even come out in questioning from the panel, was how do you provide for that scenario but not open the door to anyone just sort of carving off extra lots? And
yeah, it's a problem, isn't it? I know, I recognise
I
that.
think if you can do that, and I think that, and CDL, to be fair, put forward some ideas that they have about how that might be overcome. I do have some sympathy for their proposition, that actually they're trying to facilitate sensible urban growth rather than frustrate it.
Can you have another look at that in your reply?
Yeah, okay.
Okay.
Any other questions from anybody? All right, thanks, Ms. O'Warder. Let's hear from you. Thank you.
Well, Jono, to lead on from that. So I guess I'm just going to provide a highlights package rather similar to Jono there. And probably reflecting on Jono's observations as well, I just wanted to say that I think, particularly rural subdivisions are very contentious, issue for the district. And, I think that we've heard all the issues yesterday. And I guess from my perspective, I think the key thing that I keep thinking about here, particularly as you've heard a lot of submitters talking about their desire for more rural residential subdivision in the future, is that obviously the rural zone is under a lot of pressure between land use and subdivision. And I think whatever decisions the panel make need to bear in mind that if we are going to loosen off any of the 5 pathways that I presented in my opening, we just need to be aware of the consequences that could have and unfold. So, as I'll talk a bit more about in my response here, there's still a few concerns, and certainly there were some submitters that raised some really good points. So I'll talk to kind of the key ones today, and obviously look towards providing a written closing statement, and there's still a little bit of documentation that I'll need to circulate with that. So you might recall I mentioned a comparison table looking at the provisions from the operative right through to what we're recommending. So I'd like to provide that in our closing statement so that the panel have got that clear picture in terms of where we've come from and where we're heading.
I also would like to pick up on obviously a few drafting issues with the rebuttal appendix there. There were a couple of things I think, Mr. Mitchell, you pointed out to me. So I think as I tie up a few loose ends, I'd like the opportunity to put forward like a new version there.
I think we want to talk about drafting generally, because there's quite a lot of drafting that could do with quite a lot of improvement, irrespective of the merits of particular points of view. And I don't mean that critically, because in a number of cases, a submitter have said insert that, you've agreed with it, and it's been inserted, and it doesn't necessarily make sense. So I think quite a number of cases where, irrespective of any specific changes you want to make, you'll have sensed from the questioning, specific or particularly by me, there's a whole bunch of words that are used that maybe mean similar things but are used differently, in a whole range of almost proofreading and refinement that I think we'd like to talk to you about, which has got nothing to do with the merits but everything to do with clarity.
Yes. Yeah, no, agreed. So so I think the first point that I had on my list here was actually in response to Commissioner Cooney's question on the first day. Commissioner Cooney asked me about how many titles would be eligible for rural hamlet subdivision. So I've gone away to reflect on that, because I actually didn't have the answer there, because we didn't have a figure for lots that were less than the 5,000 square metres as we've provided for in that rule. So because it's existing titles, it is quite a big number, because effectively any title above 5,000 could qualify in terms of that rule. So the figure that I have is 14,465 titles, and that's out of our 16,679 titles. But bear in mind that doesn't factor in the issue around the high class soils, and obviously it doesn't factor in the combinations at which they might apply in terms of subdivision. So you know, for example, Mr. Upton and Ms. Miller yesterday presented their particular property scenario, which, you know, did obviously show that it wouldn't meet that rule. But I guess effectively what we're saying there is that as long as you can tally up to 40 hectares, any title that can meet that combination would be provided for by that rural hamlet rule. So it is a little bit of a big number, but I guess until you get a site-specific scenario, you can't really work out, you know, how many properties are actually going to be eligible or not. It's quite a difficult one to say, yeah, we're going to get this number of rural hamlets.
We just have a little bit of a discussion on that aspect, on that rural hamlet rule, because as I understand it, the policy intent, and I made a note alongside that rule, the policy intent is to reduce the proliferation of titles to maintain rural character, because at the moment you've got all these titles spread everywhere and houses can go on each individual title. And I sort of question, and I raised the question, well, putting it up to 40 hectares, you're not achieving that policy intent, are you? You're sort of saying, well, this is a higher hurdle now, so you still have the proliferation of titles on which you can build a house. And I sort of, you're not going to achieve the outcome you're seeking, which is prevent the proliferation of houses within that rural character area. So I think you should give that some more thought. The point I'm making when you come back with your reply. I'm really targeting the move from 20 to 40. That's where I'm coming from.
Yes, I picked up on that. Thank you, Commissioner. Yeah. Okay, so I'll take that one away for a bit more. And the next thing I had on my list here was Mr. Barrett raised some issues, obviously, in respect to the term allotment versus record of title. And Mr. Peter Duncan from Tompkins Wake there has been following up on that for me. We haven't reached resolve as yet. I'm still waiting to hear sort of back from Mr. Barrett to Mr. Duncan's response there, but what we're hoping there is to kind of get some agreement in terms of the drafting, but also there could be an issue in terms of the definition of record of title. So I just wanted to flag that to the panel today. Just Mr. Duncan's been working through that with me.
Yeah, we didn't expect that to be sorted out overnight. So that's,
yeah, so we'll come back to you on that point.
thank you.
Mr. Barrett also raised an issue about the high class soils, and in my view he overstated the percentage of affected titles there, and I went back to look at my my original section 42A report there, and I just wanted to clarify that my take on it is that only 12% of titles in the district are fully high class soils, and 48%, sorry, less than that, so a total of 48% are partially. So I wanted to point that out because one of the things that Dr. Rees-Hill talks about in his report is that generally until you come to do a site-specific detailed assessment of soils, you know, a property that might look like all LUC 1 through to 3 might in fact be, you know, contain pockets of, you know, non-high class soils, and vice versa. There might be a site that is deemed to be non-high class soils that could also prove to have some high class soils on that as well. So I think that to simply say that there's not going to be opportunity because of high class soils until an assessment's done with that site specific analysis, it's going to be a bit difficult to say for certain that, you know, it is actually going to prevent everybody from subdividing. So the next thing I just wanted to go through is just a response to Mr. Rowe's point yesterday in regards to the prohibited rule PR4, where he talks about this being a really unfair rule that he doesn't consider as preventing double dipping, and he used an example of where the title is, you know, amalgamated together and that lot being transferred away to a receiver site. So my take on that rule is that it's not unfair. The applicants who have utilised the transferable subdivision provisions have done so knowing that the development potential from one rural lot gets moved to another site and obviously developed at the receiver site. And then as a consequence of that subdivision, the lots then get held together in one title or often resurveyed into one lot. And what that rule is trying to do there is to stop the general subdivision rule applying again, so they come back and actually benefit again for title dates after the 6th of December 1997. I do want to just point out that there are still options there as far as the conservation lots and particularly the boundary relocation and the rural hamlet provision, which are exempt in that. So it's not it's in my view, it's not unfair. So I just wanted to raise that with you. So the next bit, I just wanted to respond to Middlemouth Farms, who obviously presented quite a significant chunk yesterday. My view on the transferable issue is that I'm still concerned that the proposals to, you know, putting forward a transferable regime is, you know, it is going to have a massive effect in terms of what has been presented. And something that was quite alarming yesterday was when Shane Hartley provided his estimation of 1,200 square kilometres, which equates to 120,000 hectares of our rural land. So I just wanted to make the point here that that's actually a third of our rural district, our rural zoning, which is 310,000 hectares. And if you compare this even to our country living zone, which is only 3,000 hectares, it is a significant chunk of rural land. So
it's not feasible though to develop, or I mean, it would be incorrect to assume that that's all of that is going to become rural in some way, though, isn't it? Because it's got to be tied to the amount of and the extent of which habitat and so forth would be created in order to utilise that. It's really only saying this is an area within which it can occur,
yes,
theoretically, as opposed to all of that 1,200 square kilometres is going to end up in houses.
Yes, and I think the other thing in that is that the area does include other zoning as well, so it's not necessarily reflective of just, you know, rural zoning there. So I guess not knowing kind of the implications of that are where my concerns lie, and the information that that we have there, you know, even in terms of what the potential output would be from that subdivision option is a little bit unknown. So for that reason, I'm still a bit nervous that could unleash you know, quite detrimental consequences. So but I do accept that there are benefits, and I do want to talk through the benefits that I saw in the Middle Miss presentation yesterday. And so I think, you know, with respect, just coming back to the transferable option there, if it were a well-designed framework and it did appropriately locate the lots, I think it was Mr. Forrester yesterday that pointed out that, you know, that it can be done, and I don't disagree with that at all. But they need to be appropriately located in order to ensure the planning outcomes and also that it aligns with our strategic growth objectives for the district. So so that's my position still on that issue. But I do want to talk to the panel about the benefits as far as the restoration and enhancement planting that's been put forward.
Thank you, that would be very helpful.
And I want to emphasise that this comment is made in regards to these being in situ, obviously given my view on transferable subdivision. So I did see some real benefit in the evidence that Mr. Forrester and certainly Middle Miss put forward in regards to protecting you know, streams and waterways, and also took the point on about areas that are not identified as SNAs. So you might recall from my rebuttal, I did raise the point about how many potential non-SNAs, the SNAs that are mapped using our council data that don't meet the criteria. They can be obviously planted up, and they can go through the discretionary pathway that we have provided for there. I've taken on the point about the non-SNAs though, and so I guess I just want to focus in on that for a little bit. So I've had a little think about that, and I think that we would need to do some more work around producing a pathway for restoration, enhancement planting and riparian planting to make sure that you know, we've got some good parameters around that. And there are some good examples out there of rules, particularly over at the Auckland Council provisions. There is an example that I wanted to raise with the panel, which is the Whitford precinct. I'm not sure if you're familiar with that, but that one in the Auckland Unit 2 plan actually does talk through the same kind of things that we're looking at here, and it's got some quite specific parameters around, you know, how far to a waterway you need to be, and the requirements, which are pretty similar to what we're putting forward in our conservation lot rule. So that's things like your fencing, the legal protection, and obviously planting requirements, what we would expect there. and ongoing management. And so I guess we would need to work through, you know, what ratio of protection or sorry, enhancement or restoration would be looking at in order to get, you know, 1 lot, 2 lots, 3 lots, or more than that, on the basis of, you know, what work they're doing. And I think the evidence in discussion yesterday was certainly helpful to really understand the costs that are associated with that. And I think I hadn't really seen anything in that regard. So I think that was really, really helpful from my perspective. So I think that's one example. And the other example I wanted to raise as well is that you might be familiar with Plan Change 14 that went through the Environment Court back in 2013. There's an area in there called the Environmental Enhancement Overlay Area, and that provides incentivisation for the protection of identified like ecological corridors. So the planning maps currently do actually identify streams and key waterways that were being encouraged for protection, and there were incentivisations around that to make sure that, you know, they were.
Is this in your operative plan?
This is in the Franklin section of the operative
okay.
plan. Yes.
Yeah.
So we do have provision, but the EOA is such a small portion of the district. What we need here is a fit across the entire district. So although we've done the work identifying those areas, that doesn't extend across the whole Waikato, obviously. So what we need here is a rule that's going to be fit for purpose, that could enable areas, you know, where waterways need to be fenced off and protected, and enable that enhancement planting to occur. So, yep.
Yeah, just on that point, I suppose one of the issues is whether you confine the, in addition to your conservation rule, whether you then have a separate rule to create in situ, a further in situ title or titles through limiting it to the protection of waterways, riparian, you know, riparian planting. Is that something that
yes,
you could
yes.
look at?
Oh, absolutely. And I think in addition to that as well, Commissioner Cooney, is to also reflect on the conversation around wetlands. And I think at this point, one of the things with the wetlands, I actually did agree with the evidence that came in around wetlands. One of the things that's really difficult with the data that we have is it doesn't differentiate wetlands from indigenous vegetation. So I think that if
you could have a rule that applies to riparian planting in wetlands.
Yes, that's right. Well, that's my thinking at the moment. And I think, you know, the other provision, the pathways that we've put forward in terms of the recommendations at the moment, you know, is focused on restoration and enhancement planting, but it is very narrowly focused only on bringing those identified SNAs up to, you know, the thresholds that we've got in the conservation lot, you know, the general provision up front there. So
I suppose there could be seen to be a distinction between that sort of a new rule that you could look at, riparian plantings and wetlands, to simply, well, I'm going to pick a paddock. I'm going to pick a paddock out, and I'm going to replant it in a whole lot of natives and that, and then I'm going to get another title. It seems a little bit artificial. Somewhat.
Yeah, I've had some experiences with those types of applications, Mr. Cooney. We need to be really careful of how we frame this. So like I said, I think that the expectation is that we're really clear about what it is that we're wanting. And the other thing that we need to put some thought into as council is how we're going to monitor and measure this, because The Whitford example is very clear about a monitoring plan that comes into council, and you know, that's something that our council hasn't really done or seen before. So we need to be you know, on board with what that's going to look like, so we can implement that when the applications start to come.
I think something that comes to my mind on this discussion is a time frame between planting and then being, if you want to say, operative enough to actually then apply. Because I think, picking up on the point, you can put up a fence and put a few plants in there and sort of say, well, I've already done it. But in actual fact, it's got to get established. And I think it's probably about, in my view, about 4 years before it'll be well enough established to be able to be certified as a qualifying area.
Yes, and my experiences on that, so some of the evidence actually did raise this point as well, that it was unfair that the planting needed to be implemented prior to even making an application. But generally, I think that some of the examples I have seen is that they require it to be in before a section 224C would be granted. So if 4 years is going to be the time of establishment, you kind of need to work out at what point is it going to be successful, and that's part of the monitoring discussion that we would need to look at, because like using the Whitford example, you know, obviously there's going to be some checkpoints to make sure it hasn't died, because we've seen that a lot. You know, you put the planting in and within the first you know, drought it's all gone, and then they need to replant. So there has to be some good measures and checks and balances in there to make sure that whatever trigger we come up with, it's going to be appropriate.
Yep.
So so that's pretty much all I was going to cover. I think Jono's kind of summarised the feel of the hearing quite well, and from my perspective, I share the same kind of views. It's probably just worth mentioning that I haven't changed my position on some of those key issues around the title date, the activity status from dropping from non-complying to less in terms of general subdivision or the other rules, and certainly in terms of the prohibited status, I haven't changed my view on that either, because it is a provision that has been in the plan for some time now, and it is doing its job. It was a really tough decision, obviously, working through the title date implications, and as I mentioned in my opening, the consequences of opening that floodgate are quite severe for the district. I will kind of leave you with the final point about our district. We actually are one of the leaders in terms of the number of rural lifestyle properties across the country, and you know, I think that this is our opportunity to just take a step forward in terms of making things a little bit tighter, because I don't see that as a good thing. So I'd like to think that where we head from here, you know, is making a difference, particularly in terms of protecting our rural land for the activities that need to happen there that can't operate anywhere else, and also to protect those activities from reverse sensitivity of rural residential lifestyle activities. So that's all I have to say in closing, and obviously I'll follow that up with a written summary. Oh, and the timeframes for that. Would the panel be happy with a 3-week timeframe around a response, just in terms of pulling together those proposed rules for you, and obviously redrafting and the closing statement?
I don't know. What does the panel think about that? That seems rather a long time. It's my immediate reaction, but I'd rather us get, you know, the quality as good as it can be, as opposed to saying, well, we've done what we can in the time available. So why do you need 3 weeks?
Well, obviously I need to think out the rule framework for the enhancement. You know, planting requirements. So there's that, and obviously I need to work through the drafting of the rules that we've put forward and work out some of those issues, obviously with Mr. Barrett. So yeah, I mean, I think.
Okay, I'm not criticising 3 weeks. I'm just trying to understand why you need it, and I think you've explained that. I think there's, and I don't want to labour the point too much, but it's not just the rule drafting that needs a microscope over it. So does the drafting of the objectives and policies. And I accept the point that there's a high degree of consensus about what they should say in principle, but there's a lot of drafting that if you don't do it, we will. And I'd much prefer you and Mr. Cleese to run, a very forensic eye over the drafting than simply just to leave it as it is and leave it for us to make clear and remove ambiguity and so on and so forth. So that would tend to add weight to the time frame that you're seeking, I think. But let's see what the panel's got to say about that.
I don't have any problem with the time frame. I think we've also got to, Mr. Chair, think about the whether that time can also be used to talk to the poultry people there. So in principle, I don't have a problem with it. Just on the drafting on that point, yeah, like there's things like I saw was the health and welfare of the land. Well, I wonder, well, it's sort of, you apply health and welfare to people rather than the land. I wonder whether you're really saying the productive potential of the land rather than that sort of language. I don't know, just have a look at that sort of.
I think that's right. That was my comment the other day too, not on that one specifically, but there is quite a lot of planner speak.
Yeah.
If we can express it in plain English and say the same thing, that would be our preference.
Yeah. There was just one other before I get off the screen. Just on the water, on the boundary relocation one rule, we heard from one submitter who challenged the requirement for the records of title to form a continuous land holding, and he said, he gave the example, it's not uncommon for a farmer to want to sell to the back paddock to the adjoining farmer and bring that back paddock into the other farmer's operations. So do you want to give that some thought?
Well, just in response, just off the top of my head here, so that type of, because it wouldn't meet the criteria, obviously it would fall into the next activity status. I don't know how common that type of scenario is, but I'm certainly happy to take it away and
maybe Mr. Fulton or Ms. Gibb can give us some.
Well, I know that. Yeah, we had a boundary adjustment with our neighbour for about 6 hectares just recently. It took a long time. I don't know what the hold-up was, but there was, I think it does happen from time to time. Dines, what do you think?
Yeah, it might. It's not. Well, there's been a huge amount of amalgamation in Waikato in the last 20 years, and I think most of it's probably settled now. But there could be the odd place where it still might need to or request a boundary relocation for small amounts. But I don't know that's going to be a very big deal in the whole of the scheme of things. I think it's pretty small, probably.
I think just to add in there too, Commissioners, one of the things that we have changed since the operative provisions is the requirement for it to be in the same ownership, which was causing all sorts of grief. So I don't know whether that's been a problem in terms of any applications, but we've gone away with that. And so, yeah, that's been a bit of a problem for landowners, and I know about that one. So.
All right, that's me.
Thanks, Mr. Cooney. Can I just ask what one? It is a drafting issue, but I think it's an important one. And this is the urban expansion area avoid policy that I think it's 5.5.2, and it arose in strategic directions from Mr. Matheson, and there's a bit of conversation around that in both of your reports, both the land use and the subdivision report, and you've said that the redrafting of 5.5.2, even though that it's got the word avoid in it, it doesn't mean avoid full stop, and hence a non-complying activity change is warranted. I just wonder whether the drafting of that is still fatally flawed, and if I can explain it, why I think that. The wording that's been proposed says, avoid subdivision use and development within Hamilton's UEA to ensure future urban development is not compromised. My reading of that is that is an absolute prohibition, because the subdivision is to be avoided because doing so will not compromise the future urban development of Hamilton. I think the intention of what is intended by that is to say avoid subdivision use and development within the AEE where future urban development would be compromised, which I think is a fundamentally different purpose, because the way it's drafted says that you are to avoid this because the outcome will be to avoid future urban development being compromised. Do you agree with that, or am I reading more into that than what I should be?
No, I think you're right.
And that's where I raise that because it's fundamentally important, isn't it? You know, it's the sort of thing that would have lawyers and planners, you know, jumping up and down for years trying to figure out what it means. And I just use that as another example of where a really forensic microscope over the wording is necessary, I think.
Yeah. And Mr. Chair, it's a very good point you raised too, because it connects back to the point I made about CDL and the land development opportunities there.
Yeah, exactly right.
Yeah.
So we would really encourage that forensic look at the drafting, and we can, that will be helpful to us to the extent that we then might need to think about whether that raises any issues of fairness to other parties. We'll worry about that when we get your reply. My initial thinking is that if all we're doing is making the wording clearer and removing ambiguity without changing the purpose, that's fine, because that's something that we could do in our decision anyway, and all we're doing is getting you to assist us in that exercise by having a first crack. But let's keep our options open on that. Sorry, Ms. Gibb, I think you might have been about to say something.
Oh, no, I was just thinking about that UEA area and our conversation offline about the fact that it's actually boils down to the infrastructure costs as to whether whichever council wants it or doesn't want it to happen. So it's just a matter of if there's a need and if there's a will, and if both councils agree, then there has to be a pathway. So that's why non-complying seems better than avoid, which seems to mean don't do it in my limited experience. But I'm just trying to make sure that there's no hooks. And as I said, at the moment, there's a good communication going on between the two councils, but we don't know when whether that'll stay like that or whether it will change, or at an election cycle, new politicians come in. So I think we have to make sure the rules are right in case things go.
No, absolutely. And that's why we're very keen to make sure that the words say what the intention of the words is, rather than their literal interpretation. And that's why I've made a big deal of the point, because I think it's fundamentally important that we get it right.
Yeah.
All right. Is there anything else from the panel?
No.
There's just something that does raise a few concerns with me, and this is over the when we talked earlier this morning, Middlemiss's applications and submissions yesterday, is that the water space is ever changing, and the requirements of the Regional Council over what is going to be required as of essential in the way of fencing and setbacks and so on from rivers and streams is going to significantly increase, I think. And I just feel that, you know, there's a huge amount of waterways and a huge amount of area there. And I just want to be careful that we don't sort of allow it too easy for people. They're going to have to do it anyway by compulsion, then to be able to grab a benefit out of it. That's not what is intended in the Regional Council's water policies and fresh water, but it could end up being a de facto way of sort of saying, okay, we'll comply with that, and then we'll be entitled to additional title. Yeah, I'm just a bit nervous about that when I heard it all yesterday, and I can understand all the sentiment that was put behind it and the very, very good examples we were shown, but those people had a particular interest. A lot of others won't have that.
I think we've also got to bear in mind that we're simply at the moment asking for the council staff to reply. We'll need to obviously consider all of that material in our deliberations, which we'll get to it in due course. I do want to make the point that while we've been, this is for the benefit of those submitters and for the record, that in having this conversation and expressing any views, they're simply to tease out the basis on which staff and advisors have made recommendations to us. We haven't formed any definitive view on any aspect of this proposal yet, and we'll do that in due course. So I just want to make that clear. It's a bit like at resource consent hearings where you start asking people about conditions and people say, why are you talking about conditions? Because you haven't made the decision whether to grant consent or not. And we're in the same boat here. We're exploring what if scenarios so that we understand the implications of various outcomes. And none of those outcomes have been determined yet. So I think on that basis, we can adjourn. You've mentioned 3 weeks. That would make it a Thursday. I think at the risk of being overly generous and being accused of being soft, why don't we make it 5 o'clock on the Friday? Because that's got a nice round ring to it. And we'll issue any further directions as to whether this hearing needs to be, well, whether it can be closed at that point or whether we need, well, we think there's merit in having further conversations with people. But just before I do, Mr. Cooney raised the issue, and I just want to check with what the view is, and it may have been mentioned that I may have missed hearing it. Is there value in further conversations with the poultry folk in relation to what we heard from Dr. Forrett this morning, or is your view remain unchanged on that? I know you made some mention of it, Mr. Cleese, about what farming should be and what intensive farming should and shouldn't be. But is that an area where fruitful discussion should be held, or have you got a pretty clear view on what you think the result ought to be?
I think I've got a pretty clear view. If they were to provide anything that would be useful, it would be more around actually expert evidence around typical kind of odour and noise type setbacks from facilities to inform those a reduction in setbacks. I think from the evidence, I've got a good understanding now of the diversity of what makes up poultry. So it's, you know, there's free range, there's eggs, there's meat, there's hatcheries, there's breeding sort of stock, and they're quite different things. So I've got to, you know, their evidence has been helpful for teasing that out for me. I'm always happy to sort of talk to submitters, but likewise I'm sort of cautious of not.
All right. Well, I think we'll leave it to you to talk to whomever you want to talk to in terms of finalising your view.
Okay.
If that makes sense for you to liaise with them or anybody else, obviously feel free, but we're not going to issue any directions about who you should or shouldn't engage with.
Okay.
We'll leave that to you to determine.
Your discretion.
Okay. No, happy with that.
All right, well, thank you, everybody. Really, I think on behalf of the panel, we do appreciate this has been a pretty full-on 3 days, or nearly 3 days, but the way in which the hearing's been conducted by those that are participating has been helpful. We appreciate the degree of cooperation there have been between parties, and that's very helpful to us going forward. I will end, though, with on the record again for those parties that dropped a bunch of new information on us at the last minute and or elected not to comply with our hearings related directions. We're going to be running a much tighter lens over that for subsequent hearings, because it does mean that staff and the panel are put under a huge amount of pressure late in the piece trying to reconcile everything. So I started out with a grumble and I'm finishing on a grumble, but that shouldn't detract for the very pleasant way in which the hearing's been undertaken. So on that basis, we'll adjourn. Thank you. And the panel's going to get together on another link just to have a bit of a debrief on where we've got to. So we'll finish this particular screen and